All rise. The Court of Appeals Division 1 is now in session.
Thank you, gentlemen. Please be seated. This is the time set for oral argument in Sally Ann Beaver versus American Family Mutual Insurance Company. Let's begin with introduction of counsel for the appellant.
Greg Como and Spencer Crawford appearing on behalf of the client.
Thank you. For the appellee.
Kevin Chapman on behalf of Sally.
Thank you very much. Let me go through, please, gentlemen, you can be seated, a few preliminaries. First, as you probably know, each side will have 20 minutes. The appellant may reserve time for rebuttal. It'd be useful to the court that when you go to the lectern, you would give us an estimate of how much time you would like for rebuttal, and then we will do our best not to poach on your time so that you end up with the rebuttal time. Let me advise counsel that we have carefully reviewed the briefs, applicable portions of the record. We've discussed in conference the case, so we're familiar with the issues and the arguments that you have raised. We are recording the proceedings today, both audio and video, and you can go to our website to see your recording, so that the listener or the viewer can appreciate what's going on. When you go to the lectern, if you would please restate your name. That way the viewer or the listener can follow along. And I think with that, we'll go ahead and begin. Counsel for the appellant.
Thank you, Your Honors. My name is Greg Como, and I'm representing American Family Mutual Insurance Company in this case. I would like to reserve 3 minutes for rebuttal. May it please the court, counsel, this is an issue of straightforward statutory construction. ARS Section 20-259.01, which is the UM and UIM statute, clearly states who must be offered and afforded UM/UIM coverage, assuming that the named insured purchases that coverage. It states that persons insured under the policy are those people that must be afforded UM and UIM coverage. What that phrase persons insured means is persons insured under the liability section of the policy. It's undisputed that in this case, plaintiff Sally Beaver is not a person insured under the liability policy or liability coverage of the policy because she owned her own vehicle. One of the things that I think you'll find noticeably absent from appellee's discussion here today is any discussion at all of the statute, because appellees have no basis under the statute itself to seek UM and UIM coverage in this case. Instead, they rely on some public policy argument that has no identifiable source in Arizona law. What this court has said about the public policy issue is in the American States versus C&G case, which is at 186 Arizona at page 426. This was cited in our brief. And I quote, "Public policy does not restrict the parties' rights to agree on who is an insured. Public policy precludes an insurer from denying UIM coverage to an insured, but it does not preclude an insurer from denying UIM coverage to one who is not an insured." And that's exactly this case. The parties were free to agree on who is an insured, and they did so in the contract. Sally Beaver does not meet that definition. Therefore, public policy does not preclude American Family from denying UIM coverage to Sally Beaver because she is not an insured.
So the argument is that the statute 25901 says that UIM and UM coverage has to be offered to persons insured under the liability coverage of the policy. And in this case, the persons insured was the same under the UIM coverage as it was in the liability. And under American states, there's no restriction on whom the parties may agree is the person insured.
That's exactly right, Your Honor. That's exactly our argument. And that's, I'm sorry.
So, are there really no limits on the definition of persons insured about who may be defined
or excluded? Could you have a family policy like this, family policy, which is actually says the only person insured is the named insured, dad?
You could define it that way, I believe. You're correct. I think the marketplace would probably prevent most insurers from doing that because other insurers are going to provide broader coverage than that, and that's really what's driving who's included. The statute itself does not say that spouses must be insured, for example. It doesn't say that any family member must be insured under either the liability or the UIM coverage. It does, of course, under the liability statute, you do have to extend coverage to permissive users of your vehicle. That's per statute. So that would be an example of somebody you couldn't exclude would be a permissive user.
What do the very confusing, at least to me, household exclusion cases have to do with this case?
Well, I'm glad you raised that, Your Honor. They really have nothing to do with this case. The household exclusion cases deal with the named insured's own claim for liability coverage. And what those cases hold is that, first of all, so the exclusion comes into play, if at all, when a family member of the named insured is injured, and they're suing their own family member, the named insured under the policy. And the question there is whether that named insured is entitled to liability coverage, not UM or UIM coverage, liability coverage. And that exclusion attempts to preclude coverage for the named insured there when it's a family member that's injured. And what the cases have said is...
I'm sorry, say that again. The named insured does it attempt to exclude or limit the named insured's coverage?
Yes.
Okay.
Liability coverage. And so what happens in...
Because you're saying that because the family member is suing Papa.
Exactly.
Or Mama for the cause of accident. Okay.
Exactly. So in this case, if Sally Beaver was suing her father, that's where the household exclusion. Now, what the Acrino case says is you cannot enforce that household exclusion within the 1530 statutory minimum coverage. But it's not because it's a family member that's suing you. It's because you can't enforce any exclusions within that 1530. That's mandatory coverage. That's what Acrino stands for. It doesn't have anything to do with the fact that the plaintiff in that case was a family member. In fact, what Acrino goes on to say is, look, this exclusion is not against public policy, even though it excludes liability coverage for family members. It's just you can't do it because of the Financial Responsibility Act. You can't do it 1530. It is enforceable above that limit, provided it doesn't violate the insured's reasonable expectation of coverage.
So to recap, the household exclusion, under your view, is where the name insured is making a claim for liability coverage on his or her behalf, where the name insured is being sued by a family member.
Correct.
Okay. And so the issue then is, does that exclusion, if it were to be effective, eliminate the named insured's coverage?
Exactly.
Okay. And of course, our cases have recognized that that cannot be done under the 1530 limits of the Financial Responsibility Act.
Exactly.
Okay. So it really has no application here.
It doesn't. It's completely apples and oranges. Mm-hmm. And in fact, as I mentioned, Acrino does clearly state that that exclusion above 1530 it does not violate public policy, despite the fact that it's a family member that's being sued. And that's why we have all those subsequent cases trying to determine whether that exclusion violates reasonable expectations. Because if it had said it violates public policy, we wouldn't have all those later cases. The cases that the appellee is primarily relying on are the Higgins and Calvert cases. Now, why those cases are harmonized with all of the other Arizona law, as well as the law from other states that have similar language of persons insured, all of these cases can be harmonized on this single principle, which is if you're insured for liability, we cannot exclude you for UM and UIM coverage. That's all that Higgins and Calvert stand for, because in those cases, the insured, the claimants, the Sally Beavers in those cases, were actually insureds for liability. And so where the insurers went afoul of the statute in those cases was simply that they couldn't exclude them from UM and UIM coverage. But the legislature has drawn the line very clearly. It's a bright rule It says if you're insured for liability, then you have to be insured for UM and UIM coverage, assuming the insured purchases that coverage. That's, in our scenario, that is what the public policy is. The legislature has defined that as the public policy, and we can't reach out and just substitute any other arbitrary public policy in place of that statutory language. And of course, there is a policy reason for this limitation of who is an insured. And that is simply, if I'm an insurer and I insure you and I know what cars you have and I put those cars on my policy, it's reasonable for me to understand in some sense of what my risk is. But if you have 3 kids or even 1 kid living in your house, or it could be another relative, wouldn't necessarily have to be a child, who has their own vehicles and they have their own right to purchase coverage under the statute, UM and UIM coverage on those vehicles, and they choose not to do so, as Sally Beaver did in this case, then it's not fair, and moreover, it's impossible to underwrite those unknown risks for the insurer in that situation. So there is a strong policy reason behind what the legislature has done, which has said, if you're an insured person for liability, then we know who you are. You're in this universe of people. But if you're not, then you're not entitled to UM and UIM insurance. It's a straight, bright line rule. In fact, there's not a single...
What does the record show with respect to Ms. Beaver's age? I'm assuming she's a young adult.
That's my assumption, Your Honor, and I don't believe there's anything in the record on that issue. There's not a single case, and I think this is important, that we found anywhere in the country where a lot of states have this similar language about UM and UIM coverage must be provided to persons insured. It's very common language. And we cited 8 different states with similar policy language, and all 8 of those states came down the same way that we're arguing in this case, which is that if you're a person's insured, then it's okay to not provide coverage to that person as long as it's true for both liability and UIM insurance, if they own their own vehicle. And those cases were cited. There's Connecticut, Florida, Indiana, Minnesota, Missouri, Illinois, Iowa, and Michigan. And what I think is also important is that in the Higgins and Calvert case, particularly it was Higgins, actually relied on some of those states to reach its result, because in several of those states, Missouri, I believe Connecticut was another one, Michigan, in the situation where they tried to do what the insurer did in Higgins, which was just exclude them from UM/UIM only, the court looked at those states and said, well, those states don't allow you to do that if they're insured for liability. But in those same states, when in fact the language is like American Families and the person is not insured for either liability or UM and UIM insurance, those same states reached the opposite result and said that is an effective limitation on who is an insured. So Higgins and Calvert did go outside of Arizona to look at what other states were doing, just as we're asking this court to do here for guidance on this issue. There's not a single case that appellee has cited in Arizona or any other jurisdiction.
Let me ask you, as I recall from reading some of the out-of-state cases and looking at the law in those jurisdictions, some of the jurisdictions, the courts had actually upheld what we would call in Arizona the other vehicle exclusion. So they had acknowledged that that was enforceable. So it would strike me that American Families' reliance on the case law from those particular states would not be very convincing or not very applicable here.
Your Honor,
because remember, we're starting from the presumption you cannot have an other vehicle exception as a carve-out to someone who's already entitled to insurance, a liability insurance.
To the extent that those cases stand for that, then I agree that those would be
not as persuasive.
Not as persuasive as well stated. They're certainly not contrary to our position, but they may not be as persuasive as those states with essentially the identical rule that Arizona follows. And we've cited those cases. Most of those cases are not only the identical, basically the identical statutory language, they've been applied the same as Arizona did in Higgins and Calvert, and we're talking about the same policy language, where the person is defined to not be a relative because of their ownership of a vehicle. So they're very factually similar. And as I was saying, I don't believe Appelli has cited a single case in Arizona or any other state where, on these facts, with this statutory language, the insurer has been required to provide the coverage. So Arizona would really be out there completely on its own if the trial court's decision were upheld in this case. Lastly, I'd like to just briefly touch on the reasonable expectations argument that Appelli has made. And again, this is another argument they've made without any authority for it. First of all, it wasn't in the complaint. It wasn't in their original motion. It didn't surface till the reply brief, so it's our position that argument has been waived. But should the...
Let me ask you about that. And I understand this entire procedural posture of this case has been unusual. That's why we've asked you to go back a couple times and get this clarified. You are correct that the reasonable expectation claim, if I can call it that, is not in the complaint. But of course, this came up on a motion to dismiss. It was briefed, although in an unusual fashion. The court decided it was moot in light of the pending motion that you had filed, the motion to dismiss. And if all things had gone forward, I imagine that Ms. Beaver could have filed a motion to amend the complaint to add this in. Because as we know, under Rule 15, leave should be freely granted to do that. So in light of that, it strikes me that we're being awfully technical to say that this is waived and forever waived. Rest in peace. I'm just not persuaded by that.
I understand your position, Your Honor, and I'll address it on the merits then.
Yeah.
And what my point on that was that there isn't a single Arizona case dealing with the reasonable expectations doctrine where a stranger to the contract has been allowed to argue that she had a reasonable expectation of coverage under the contract.
But aren't there Arizona cases that acknowledge that I can prove up my father or my named insured's reasonable expectations? She could make the claim, and she could present evidence from her father and perhaps the broker here. But, she could make the normal cases handled in the normal course and present the evidence that her father's expectation when he bought the American Family, I think it was called the family car policy or whatever it was called, that he expected that she would be entitled to uninsured motorist coverage.
If there are such cases, Your Honor, I'm not aware of them. In fact, the Alcala versus Mid-Century case was very somewhat similar to this case in that it was a passenger on a motorcycle, and she tried to raise a argument of reasonable expectations. It was actually the driver of the motorcycle that had the policy, and the court said, no, you're not a party to this contract, so you're not the person to bring a reasonable expectations claim. And if you think about the reasonable expectations doctrine, the reason that makes sense is it's a principle of contract interpretation.
Mr. Como, let me ask you this. If, in fact, there is, and we can't all know all the law. I mean, you're a good counsel, but we can't know everything. But if, in fact, we find Arizona case law that recognizes a party who is not the name insured in her contract, like Ms. Beaver, she's not the name insured, nevertheless, she can present evidence of her father's reasonable expectation so she can pursue that claim. Would then that allow her to pursue the claim if there's Arizona case law that acknowledges that?
I would, Your Honor, I'd really have to see that case law to provide an intelligent answer to that. So, if there are no further questions, I'd like to reserve the rest of my time for rebuttal.
Sure.
Thank you.
Okay.
Kevin Chapman on behalf of Sally Beaver. Appreciate your time and your diligence in preparing for this oral argument on behalf of co-counsel myself. What Mr. Como doesn't agree with me is that Sally Beaver was in fact covered by her father's liability coverage by being a member of his household. So when they say she was not covered by his policy for liability, yes, she was.
And how was she?
Because if she would have been in his truck and did an action to harm somebody, she would have been covered by his liability policy. If she'd have been injured or on some other vehicle other than, let me back up, if she had not owned a vehicle, she would have been covered by liability as well. If she'd driven her dad's pickup truck, she would have been covered by his liability policy.
That's not what happened here.
That's correct.
Right. So, I mean, forgive me, but it's kind of like in another world, she might have been an insured and entitled to liability, but we have to deal with this policy and these facts.
I understand. I'm just speaking to the issue that was brought up. The other issue as well is if she had been harmed by her father, obviously she would have been covered by the liability policy as a victim. UIM coverage is in fact for victims, not for actors.
But the statute requires that UIM coverage be offered to persons insured under the liability policy. When we have a liability section that defines persons insured to exclude her, why doesn't that answer the question?
That's a great question, Judge. First of all, the statute doesn't speak to any liability coverage in the statute. And if you look at subsection G, which I've cited in my brief, underinsured motorist coverage includes coverage for a person. It doesn't say insured. It doesn't say insured person. It doesn't say anything. It says a person. That's what the legislature said. So to answer your question, if she is covered through liability, if she's not covered by liability coverage, she can be covered through the UIM coverage, is what we're advocating, obviously. I'm not sure I answered your question, Judge. I'm a little confused. Could you ask it again?
Well, I'm sorry. I'm probably confused because I don't have the language of the statute here. I understood that the statute requires UIM coverage to be offered to, my word, anyone or any person insured under the policy.
Correct. That is correct.
And as I understand the policy, it sets out who is insured and pretty clearly excludes a relative or a person who would be a relative but for the fact that she owns her own car.
That's correct.
So how is it that the daughter here could be construed to be a person insured under the liability section of the policy?
Well, I've already mentioned that if she's driving her father's truck, she would be covered in the liability section.
Oh, well, how
Even
is
if
that?
she owns her own vehicle,
How is
owns her
that?
own motorcycle, she's still covered by driving her father's truck if she harms somebody.
That's presumably because she had permission to drive this truck. And that's
I'm
the whole-
assuming that.
And that would be a claim against, that would
And
be a
that's
claim against the
yeah.
owner of the car.
Well, in Arizona, the insurance is driver first, or excuse me, vehicle first, driver second. So if her father says, take my truck to the store and she hurts somebody, his liability section covers her.
Okay.
Even if she owns her motorcycle. Keep that in mind. If she's using the insured vehicle, okay, that's why to me this is a backdoor other vehicle exception. They're saying, well, she's not an insured, even though she's his daughter living in his home, simply because she owns a vehicle. But UIM coverage is never tied to a vehicle. It's tied to persons. It's tied to victims. It's tied to family. It's not tied to a vehicle. It's portable. That's what the courts have told us in the cases.
But she's not a person insured under the policy. And the fact that she may well, that's if she drives her father's truck and injures someone, that person can claim against the policy, doesn't make her an insured. She's not insured. I'm having a hard time, forgive me, I know you two are the experts in this. I feel like we're mixing, at least in my mind, apples and oranges. I don't see how we bootstrap her into a person insured under the policy. I just don't. I'm not following the argument.
Well, the argument is, Your Honor, that it's contrary to public policy to have the other vehicle exclusion, and this is the backdoor result the same way.
How is this the back door? The other vehicle exclusion presupposes that the claimant is, in fact, a person insured under the policy. And Higgins and Calvert make it clear you can't strip away UMI or UM coverage if they're entitled to it under the language of both the statute as a person insured. So once they are insured as a person insured under the policy, they get UMI or UIM coverage, again, assuming it's purchased by the policyholder. And you can't take it away. It's portable.
Right.
That I understand. I really have that in mind, but how does that transform her into a person insured under the policy when the definition of relative is consistent throughout?
Well, we believe it's contrary to public policy, Judge. That's why we're here.
How is it contrary to public policy?
Well, first of all, do you accept the other vehicle exclusion as void against public policy? That if you,
No question, our Supreme Court has made it clear, and we are here to follow what it has told us, that that is, in fact, in this context, void
Okay.
as against public policy.
Isn't-
I couldn't agree more.
and Your Honor, my argument to you is clearly that that's the same result, semantic game that the American family has played. Let's say, okay, tell you what, well, that didn't work, so now if she owns a vehicle, even if it's not operational, if she simply owns a vehicle, now she's out and she's not considered a relative of the named insured. Same result. We've got the same facts in Higgins and Calvert. Only this time American Family said, well, let's make ownership the relevant issue of a vehicle that she may or may not be using at the time. That's the difference.
Well, but I guess I see a larger or an additional difference. Calvert and Higgins, their starting point was the language of the UIM, or the unemployed motorist provisions. That's where they started. And they looked at the language, and the language has basically remained the same, and that underinsured or uninsured motorist coverage extends to and covers all persons insured under the policy. So they were interpreting that language. That is the language we are required to follow. And here, under this policy, she's just not a person insured. And that's where I'm struggling. If you could persuade me that or help me see my way to understanding how she is a person insured under the policy, then maybe we would be face to face with a functional equivalent of the other vehicle exception, but it doesn't seem like we are.
Well, she's insured if she's driving her father's pickup. She's at least covered and treated as an insured.
Covered, but she's
Correct.
not insured.
She's not insured. I could drive her father's pickup with his permission, and the injured party would be entitled to a claim under the policy.
That's correct.
Right. Doesn't make me an insured. Well, excuse me. I guess it does in a technical sense, but it's not. Doesn't make me. It gives Mr. Beaver cover and coverage if I take his vehicle and get into an accident as against the injured party. It protects the injured party and it protects Mr. Beaver.
Right.
Isn't it? Right.
Right. And the UIM statute is supposed to be interpreted liberally to help victims of accidents where they're uninsured or they're injured by somebody who's underinsured, which is this situation. Any exclusion is supposed to be strictly construed. The other vehicle exception that the Supreme Court acknowledges in our state and is held as the law, you won't read that in the UIM statute in 225901. It's not in there. The court said it's against public policy for the insurance company to enforce that. And Mr. Como raised the marketplace issue. It's not a fair marketplace out there. It's take it whatever we give to you. That's what the insureds have to accept, is the fact that they don't have a level playing field. So that's part of the reason why the court steps in oftentimes to say, no. You can't use that provision to bar coverage in different circumstances. So really, Judge, the distinction here is if you use another vehicle, that exception is not allowed. So they simply say, well, if you own another vehicle, that's the exception they want.
Do you agree, though, that Calvert and Higgins addressed the other vehicle exclusion in a context where the exclusion appeared only in the UIM or UM coverage, not in the policy in chief?
Well, in those two cases, Judge, the insurance company acknowledged that the person making the UIM claim was an insured. Here, American Family said, we'll change that. We'll say if you own a vehicle, now you're not an insured.
Right.
That's the only difference. Ownership, again, is the determination of whether or not they're covered. But UIM coverage is not tied to any vehicle. It's portable. As the courts have said, you could walk down the sidewalk and be injured, and you could be covered. But not in this case if you own a vehicle.
But, well, at least it seems that American Family is saying if you own another vehicle and you're insuring it, you've got liability through someone else, then you are gambling not to have UM or UIM. And so you're taking that gamble. We don't have to take that gamble. That's what I'm perceiving their definition of who Who a relative is.
Well, the other way to look at it, too, is did Sally Beaver need to purchase UIM or UM coverage on a motorcycle if it's already in place through her father's American Family policy?
But that then gets back to my earlier question. Is she, well, apparently the record doesn't say that she's over 18, but
She is.
that's the presumption.
I can give you, I can avow to the court she's a veteran of the U.S. Navy and she's in her early 20s. As I've mentioned, there's strong public policy mandating coverage for innocent victims of UIM drivers.
It's about the household exclusion, if you will. I want to make sure I'm interested in that, so. yeah,
Okay,
yeah,
the household exclusion, I agree with Mr. Como. That's not necessarily on point, but it is instructive. Those cases said that if an insured harmed a member of the family, for example, caused an accident and a passenger, for example, his wife was injured, then that family member could not make a claim on the liability portion against the driver. And the court said, no, you can't do that.
How does that affect our case?
It doesn't necessarily affect the case, Your Honor. I will tell you, though, that the household exclusion is in the American Family policy that's been found void.
Well, wait. There's an Arizona, for lack of a better term, endorsement that changes the main policy terms and specifically brings it into to accommodate Arizona law on this.
On the household exclusion?
Right.
There may be. I don't know.
Well, that's an important point when you, with respect, say flat out that American Families policy violates Arizona law when it in fact has an Arizona endorsement that is designed to bring, I thought, to bring it into compliance.
I can look that up for you if you like, Your Honor.
Well, go on with your argument and we'll check it out. But-
Okay.
Okay.
Now, what about reasonable expectations?
Well, that's an interesting, as Judge Norris mentioned, we had an interesting procedural exercise down below. When American Family filed their motion to dismiss, I countered that and filed a motion for summary judgment. There's no facts disputed at that point. And Judge Talamonte, in issuing the oral argument, essentially said that my motion for summary judgment was not going to be heard. And so then we show up to the oral argument, and Judge Padish is there, who hears the oral argument, and says, well, I'm not going to deal with whether or not that was proper. I'm going to consider it quasi-moot, and let's just get right to the meat of the merits. And that's what we discussed. So I have raised it. I'm not really sure how it was eliminated, but I've raised the reasonable expectations issue. But Your Honors have brought up an excellent point. Sally Beaver is a third-party beneficiary of the insurance contract between her father and American Family, and she can raise that issue.
But whose reasonable expectations are at issue in that argument?
I would say probably both, but more her father's because it was his contract. He signed, ultimately he agreed to the insurance contract. As Your Honors know, when you purchase insurance, you don't have the policy in front of you. That comes later. You sign up with an agent or you sign up online, and then weeks later suddenly your policy arrives, and most of us never open it up. We simply put it in the insurance file and we don't know what the terms say. And so I would say it's his reasonable expectation, but she is a third-party beneficiary, so she indeed has her own reasonable expectations argument that she can make, bring her father in, provide evidence from him as to what his expectation was, as well as...
Is reasonable expectation something that needs to be alleged in the complaint?
That I don't know, Your Honor, but as Judge Norris pointed out, I can amend the complaint if necessary. Briefly, with my time remaining, Judge Norris, you're absolutely correct. The other states' cases, several of them allow the other vehicle exclusion. I don't know if Arizona is ever bound by what another state does. The argument is almost whichever state rules first, that's the majority opinion. Everybody must follow in line or you're the minority position. I don't think we have that type of peer pressure in Arizona. In fact, oftentimes I wonder if we even follow any national trends. But
Hey, we're Arizona.
And we march
We're
to the beat
independent.
of our
We march to our
different
own
drummer.
drummer.
Yes, we do, and we all hear about it from our friends across the country. Nevertheless, what 5 or 6 other states or 3 or 4 other states do, it has no bearing on this court. This court is to determine the facts before it. And we have full confidence that the correct decision will be made, regardless of what Wisconsin did, or Louisiana, or other states like that. If there are any other questions, I'm happy to answer them.
Thank you.
All right.
I don't think so. I think
Thank you.
Thank you very much.
Thank you very much.
I just have a few points. The permissive user example that Mr. Chapman cited simply does not work, because under his, if that was all it takes to make you an insured for under the policy, then it would be true for anybody that would ever have permission to use his car. They would all be deemed insureds for any accident they might get involved in driving their own vehicles. So, for example, if Mr. Beaver were to loan the car to me for some reason, now, under his argument, then, if I'm out driving my own car, as Sally Beaver was in this case, now I'm a person insured under his policy, because at one point in time he loaned me a vehicle. So that argument is not what is meant by persons insured under the policy, that someday you may be a person insured for one specific incident. That was not the incident involved here. As far as the reasonable expectations argument, Mr. Chapman raises for the first time, perhaps she's a third-party beneficiary under the contract. Unequivocally, no. She's not an insured. That's what we've been talking about all morning. If she's not an insured, how is she a third-party beneficiary? She's not named on the policy. It's issued to Rodney Beaver. To be a third-party beneficiary, you'd have to be named or otherwise identified. Here, it's the exact opposite. The policy is saying you, because you own your own vehicle, are not an insured. So she's not a third-party beneficiary. The reasonable expectations doctrine, while somewhat flexible, is not without limits. And one of those limits is it's a contract, it's a principle of contract interpretation. So it's an interpretation that's meant to benefit those people to the contract if they don't have a reason to believe that the contract they negotiated is the contract they got. And that's who it's intended to benefit in those situations, not third parties to the contract, not strangers to the contract. And we've cited several decisions, reported decisions directly on point on that issue in our brief. Unless the court has any further questions, I thank you for your time.
Let me ask one. And you heard the dialogue I had with Mr. Chapman about whether the American family policy under the Arizona endorsement is in compliance with Arizona case law on the household exclusion.
It clearly is, Your Honor. As you pointed out, it has a drop-down provision which says if this exclusion is only enforceable to the extent that it's above the 15,000, 30,000 statutory requirements under Arizona law. So that complies with Acronell.
Okay.
Thank you for pointing that out.
Any questions? Anything else? Well, thank you. Thank you very much.
Thank you.
Let me thank both counsel for their arguments, and thank you for curing all these little jurisdictional problems that we surfaced. We know that cost you extra work, but we appreciate you doing that. We're going to take this matter under advisement. We will issue a decision in due course. Thank you very much.